Hi, Assalamualaikum warahmatullahi wabarakatuh. First of all, my name is Muhammad Azim Farhan bin Zakaria, number metric DIL201019. So we are from group 4 and my group members are Muhammad Razi Ikhwan bin Muhammad FAUZI, Muhammad HAIKAL bin ARIFFIN, one NORINA binti one AFFANDY, Nur Atiqah Firzanah binti RASHIDI, and the last one is Muhammad HAIKAL Iskandar. So today we will be presenting about the question 1, which is based on the question assignment given by Madam Asna. And we are divided into issue, we are divided into law, which is there are statutes and cases law, the application, and the last one is conclusion. So I will pass to the first presenter.
Assalamualaikum warahmatullahi wabarakatuh. My name is Iskandar Bikal Anwar. I would like to present about the issue of the case. The issue in the case was whether Mary and Julie promised to keep the offer open until Monday 1st July was a binding contract between them and Jackie and was an agreement reached between them. Also, is it whether the agreement fulfilled the element of contract to make the agreement valid? Is it whether the agreement was void because they cancelled the offer before the deadline? Is it whether the contract following according to contract had 1950? Is it whether Jackie get the job offer even though they cancelled the offer? Is it whether they can reach the understand each other to solve this case? That's all for the presentation and about the issue of the case. Thank you and Assalamualaikum warahmatullahi wabarakatuh.
Hi, my name is NORINA binti AFFANDY and my metric number is DIL211019. In this presentation, I will explain to you about the law that we use in this case. Firstly, we got section 2A of Contract Act 1950 that state when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to the act or abstinent, he said to make a proposal, which means a contract is made when there is an acceptance. For example, Mary and Julie advertised the position to the public, then Jackie saw the advertisements and went for an interview. Then Mary and Julie decided to give that position to the Jackie, but Jackie asked for some time to think about it. Secondly, we got section 3 of Contract Act 1950 that state the communication of proposals, the acceptance of proposals, and the revocation of proposals and acceptance respectively are deemed to be made by any act or omissions of the party proposing, accepting, or revoking by which he intends to communicate the proposals, acceptance, or revocation, or which has the effect of communicating it, which means by performance any act, the offeree accept the offer and such performance of the act is akin to communicating the acceptance. Lastly, we got section 2G of Contract Act 1950 that state an agreement not enforceable by law is said to be void, which means a voidable contract means an agreement which is voidable at the option of the party to the contract whose consent was caused, coercion, undue influence, fraud, misrepresentation, or mistakes.
Hi, Assalamualaikum and good evening everyone. I'm Muhammad FAUZI bin ARIFFIN. My number metric is DIL211023 and today I will present the case Dickinson vs. Dodd 1875. There was no binding contract formed. The defendant had communicated an offer for buying his house to the complainant and this offer can be revoked anytime before there is acceptance. The defendant, Mr. Dodd, wrote to the complainant, Mr. Dickinson, with an offer to sell his house to him for $800. He promised that he would keep this offer open to him until Friday. However, on the Thursday, Mr. Dodd accepted an offer from third party and sold his house to them. It was claimed that Mr. Dickinson was going to accept this offer, but had not said anything to Mr. Dodd because he understood that he had until Friday. Mr. Dodd communicated that the offer had been withdrawn through a friend to the complainant. After hearing this, Mr. Dickinson went to find the defendant, explaining his acceptance of the offer. The complainant brought an action for specific performance and breach of contract against the defendant. The issue in this case was whether the defendant promised to keep the offer open until Friday morning was a binding contract between the parties, and if he was allowed to revoke this offer and sell to a third party. And for the help, The court held that the statement made by Mr. Dodds was nothing more than a promise. There was no binding contract form. He had communicated an offer for buying his house to the complainant, and this offer can be revoked anytime before there is a sentence. There was no deposit to change this situation. Thus, as there was no obligation to keep the offer open, there could be no meeting of the mind between the parties. In addition, the court stated that a communication by a friend or other party that an offer had been withdrawn was valid and would be treated as if it came from the person themselves.
Assalamualaikum. My name is Atiqah Firzanah binti Rashidi and my metric number is BIL 211002. Rulage against grant 1828 4 Bing 653 formatting of contract, offer of sale. Facts. The defendant contacted the claimant in writing, offering to purchase the lease of the claimant's home. The offer stated that it would remain open to the claimant for a period of 6 weeks. However, during this period, before the claimant had accepted, the defendant changed his mind about the purchase and wrote the claimant once again and purporting to withdraw the offer. After receiving his second letter within 6 weeks from the first, the claimant accepted the defendant's offer. The issue was whether the defendant was contractually bound by his original letter to keep the offer open for 6 weeks, and by extension whether he was therefore bound by the claimant's acceptance within that period. The court heard that the original letter did not bind the defendant to keep the offer open for a full 6 weeks, and as much it had been validly withdrawn by the defendant and the claimant's purported acceptance was ineffective. The underlying reason for this was why it is a fundamental principle of contract law that one party cannot be bound whilst the other is not. In the words of Best CJ, if a party make an offer and fix a period within which it is to be accepted or rejected by the person to whom it is made, through the letter may at any time within the stipulated period accept the offer. Still, former may also at any time before it is accepted retract it. For be valid, the contract must be mutual. Both or neither of the parties must be bound by it.
Hi and Assalamualaikum. My name is Muhammad IKHWAN FAUZI. Number matric DIL 201063. So I'm going to present and explain about the first part of application for our answer. So based on the question above, Mary and Julie interview JT for the position for the new salesperson for their firm. As we know, before a contract can be made or executed, there must be an offer or proposal, because that is the first element of contract. So an offer is a communication amounting to a promise to do something or not to do something if the person to whom the offer is direct does something or refrains from doing something or makes a promise in return. So as we can see, we refer the statute under section 2 clause A. Offer is when one person signifies to another his willingness, he is said to make a proposal or offer. And as stated in section 4 section 1 of the Contracts Act 1950, the communication of a proposal is complete when it comes to the knowledge of the person to whom it is made. For example, if the offerer write a letter to the offeree, so the offeree knows about the offeree know about the proposal, and that is considered as a offer. A proposal can be made to an individual, also to the public at large. A proposal to the public can also be called invitation to trade. Basically, invitation to public for all the large group of public. So, based as we can see on the case of Carlyle against Carbolic, Smokeball.co is a good example of a manufacturer's offers by means of advertisement. So therefore, an advertisement for the set of goods displayed to the public may be an invitation to trade. However, in this case, based on this question, this is not amount as invitation to trade, because at the end of the interview, Mary and Julie offered the position to Jackie. Firstly, why this is not amount as a invitation to trade? It is because the offer became a real offer as Mary and Julie interview Jackie for the position. So that means the real offer be real when the Mary and Julie interview Jackie. So the invitation to trade only amount when Mary and Julie advertise the position to public. Thus, by interviewing Jackie for the position, the real offer is reached. So that is the first element of the contract, which is offer being made in this case. So that's all for me. The other part of application will be explained by our group, other group mate, which is AZIM. So thank you.
Hi, Assalamualaikum warahmatullahi wabarakatuh. First of all, my name is Muhammad Azim Farhan bin Zakaria, number metric DIL 201019. So today I will be presenting about the application of our assignment. So for your information, in this presentation, we have to find out, is there any agreement reached between Mary and Julie with Jackie on 11 June, and is there any contract formed between them? Okay, so as general, in order to form a contract, all the element of contract must be fulfilled. So as you know that the first element of contract, which is offer, was contained, but today I'm not to explain about the offer because my friend has explained about that. So today I'm going to explain further what is the next after the offer made by Mary and Julie to JK. So the first point is Mary and Julie had changed their mind. In other words, the offer of employment has been withdrawn. A few hours later, after the discussion, Mary and Julie informed Jackie through the phones regarding the revocation of the offer. So this offer can be revoked at any time before there is acceptance, and Mary and Julie also must tell to Jackie as soon as the withdrawal has taken place. Okay, so please pay attention of the word, the revocation of the offer. So why I say you have to pay attention of that word, because the revocation of the offer was involved in the question. So as additional information, there are 4 ways of the revocation of the offer can be made. So the first one is through the notice of revocation, and this is according to section section 6 subsection A Contract Act 1950. The second one is lapse of time, and this goes to section 6 subsection B, and the third one is failure of the acceptor to fulfill a condition precedent. This according to section 6 subsection C, and the last one is death or mental disorder according to section 6 subsection D of Contract Act 1950. So basically, what is the revocation? The revocation means an offer is withdrawn by the offeror. So according to Section 3 of the Contract Act 1950, there are two important elements in order to revoke an offer. The first one, the revocation must be communicated either orally or in a written form. The second one is the revocation must be done before the offer is accepted, and it means that an offer can be revoked or withdrawn at any time before the acceptance of the offeree. So the example of the case law that I can relate with the situation is in the case of Payne against Keith, and the court held that an offer can be revoked at any time before acceptance takes place. The second one is the revocation must be communicated effectively, directly or indirectly to the offeree before the acceptance. Okay, so what I can say that we can see clearly in the slide. Mary and Julie informed to Jackie regarding the revocation of the offer. It means that there are the communication by Mary and Julie to inform in order to revoke an offer. And the second one is Jackie asked if he can have the weekend to think about it. It means that Jackie still did not yet accept the offer. It means that also Mary and Julie revoked the offer before the acceptance made by Jackie. Therefore, the revocation made by Mary and Julie is valid. Mary and Julie did not bound to keep the offer remain open until Monday 1st July. Okay, so this is we can see in the case of Routledge against Grant, which is the court held that the offer may still be able to withdraw even if it is specifically stated that it would remain open for a fixed period when such promise to leave an offer was not supported by any consideration given by the offeree. Therefore, an agreement between them on 11 June was not reached because the agreement was uncertain, which Mary and Julie did not agree to be bound. So basically, what is the agreement? An agreement can be defined as a aspect that arises when an offer made by one party is accepted by the other. According to the law, an agreement is defined as a meeting of mind with the understanding and acceptance of reciprocal legal rights and duties as to particular action or obligation which the party intend to exchange. In other words, the agreement occurred when there is offer and acceptance. So in this case, in this question, we are aware that Mary and Julie had revoked the offer. It means that they are not agreed to be bound. Okay, they are not agreed to be bound. Even Jackie accept the offer, the acceptance will ineffective as Julie and Mary had withdrawn the offer. Okay, so what is the reason? The reason is so the underlying reason for this was that it is a fundamental principle of a contract law that one party cannot be bound while the other is not. As consequence, an agreement between them is not enforceable by law, and the agreement said to be void. When the agreement is said to be void, means that there is no binding contract formed between them on 11 June. Okay, so an agreement enforceable by law, in other words, a valid legal agreement is needed in order to form a contract. The contract must be mutual, must be bound, and must have the consent from both parties. And in this situation, in this question, the consent must have from Mary and Julie and Jackie. Okay, so in this question, Mary and Julie did not agree to be bound. It means that the agreement is not enforceable by law. This is according and the consequence is when the agreement is it's not enforceable by law, the agreement is said to be void. This is according to section 2 subsection G, which is stated that an agreement not enforceable by law is said to be void. Okay, so what is agreement said to be void? What is the consequence when the agreement is void? The agreement is said has no legal value. Okay, has no legal value. So when the agreement is said to be void, means there is no binding contract formed between them on 11 June.
Assalamualaikum. My name is Atiqah Firzanah binti RASHIDI. My metric number is DIL 211002. In conclusion, it appears that there is no binding contract between both of the parties as the agreement was not reached by them. The statute that had been referred to this case is Contract Act 1950, which states that, firstly, Section 2 in the bracket A, when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to the act or abstinence, he is said to make a proposal. For example, Mary and Julie advertised the position to the public and Jackie saw the advertisement and went for an interview. Mary and Julie decided to give Jackie that position, but Jackie asked some time to think about it. The agreement for offer to remain open until Monday 1st July became void, hence was not enforceable by law because of the revocation made by Mary and Julie. The statute that had been referred to this case is Contract Act 1950, which states that, secondly, Section 2 in the bracket G, an agreement not enforceable by law is said to be void. The statute that had been referred to this case is Contract Act 1950, which states that, thirdly, Section 3 of Contract Act 1950, the communication of proposals, the acceptance of proposals, and the revocation of proposals are acceptance, respectively, and deemed to be made by any act or omission of the party proposing, accepting, or revoking, by which he intends to communicate the proposal, acceptance, or revocation, or which has the effect of communicating it. For example, Jackie is not be able to take any legal action on Mary and Julie because the offer can be revoked as long as there is no acceptance made by him.